Good morning, good afternoon, and good evening. Welcome to Seminar I of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy and a member of the Bureau of the International Association of Democratic Lawyers. Our topic for today is how to resist imperialist attacks on international law. Our distinguished faculty for this seminar is Edre Olalia, Camilo Eduardo Umaña Hernandez, and Phyllis Benes. Each of them will speak for about 25 to 30 minutes, followed by Q&A. We have Spanish, French, and English translation. You can select your language at the bottom of your screen. Please put your questions in the Q&A box for our discussion. We will soon post on our website, peoplesacademy.net, the faculty presentations in English, Spanish, and French, along with written presentations and links to relevant articles. You will receive an email when the program is posted. In their war of aggression, the U.S. and Israeli militaries have killed at least 1,348 people in Iran, forced over 3.2 million Iranians from their homes, targeted schools and hospitals, and bombed oil facilities, producing toxic black rain. The Israeli military has killed at least 773 people in Lebanon, forced over 800,000 from their homes, targeted apartment buildings and public shelters, carpet-bombed entire villages, and deployed white phosphorus that burns to the bone in residential areas. But the UN Security Council refuses to take steps to stop this illegal war. Less than a month ago, the U.S. imposed an illegal naval blockade on Cuba. That is considered an act of war. The U.S. military seizes oil tankers attempting to deliver fuel to Cuba. Yesterday, Cuba's electric grid collapsed, leaving 10 million Cubans with no power at all. In October, for the 33rd consecutive year, the UN General Assembly overwhelmingly adopted a resolution calling for an end to the U.S. economic, commercial, and financial embargo of Cuba. Yet it still persists after 67 years. Meanwhile, Israel's genocide, aided and abetted by the U.S. against the people of Gaza, continues unabated. In 2.5 years, the Israeli government has killed at least 70,000 Palestinians, displaced nearly 2 million people, assassinated journalists and medical workers, targeted schools, hospitals, and tents, manufactured a famine and aid crisis, and decimated over 80% of the infrastructure in Gaza. The UN Security Council has refused to act to stop this barbarism. The General Assembly, however, acted under Uniting for Peace, which Phyllis Benes will discuss later in our program. In November 2024, the International Criminal Court charged Benjamin Netanyahu with war crimes and crimes against humanity in Gaza. Yet he continues to evade arrest. This seminar is for lawyers and human rights activists who seek to build a peaceful and just world through the use of international law, to stop the commission of atrocity crimes and ensure accountability for perpetrators and redress for the victims. Despite the attempts by the U.S., Israel, and other countries to avoid compliance with existing law, successful strategies for enforcing international law are being used in domestic, regional, and international courts and tribunals to oppose and remedy unlawful aggression, and atrocity crimes. This seminar will identify and explain some of the legal means of seeking justice through law enforcement, accountability, and redress. And now, who is our faculty? Edre U. Olalia is a lawyer in the Philippines. He is serving as president of the International Association of Democratic Lawyers, or IADL, from 2025 to 2029. He is the recently re-elected chairperson of the National Union of People's Lawyers, NUPL, a nationwide private organization of pro bono human rights activist lawyers in the Philippines. As an activist and people's lawyer, Edre has practiced pro bono or pro dio human rights and public interest law for 25 years. He served as lead private counsel who led the successful last-ditch private efforts that proved crucial to the last-minute reprieve from execution of Mary Jane Veloso, a trafficked Filipina domestic helper in Indonesia, framed as a drug mule by an international drug syndicate. He is the recipient of the recent first ever Integrated Bar of the Philippines, IBP, Human Rights Award for Luzon. Edre provides legal consultancy to the peace negotiating panel of the National Liberation Movement, represented by the National Democratic Front of the Philippines, NDFP. He is a member of the NUPL legal team representing some of the named victims before the International Criminal Court in the case against former Philippine President Duterte for crimes against humanity related to the thousands of extrajudicial killings in his so-called drug war. Edre will discuss resisting attacks on rights and international law by using international remedies and through international work, focusing on the Duterte ICC case. Camilo Umaña is a Colombian socio-legal scholar and public policy practitioner working at the intersection of research, human rights, and institutional reform. He currently serves as scientific director from 2025 to 2027 of the International Institute for the Sociology of Law, IISL, in Oñate, Spain, where he promotes global socio-legal research and interdisciplinary dialogue on justice, power, and social transformation. He holds 2 PhDs in criminology from the University of Ottawa and in sociology of law from the University of Basque Country. His research focuses on state violence, impunity, criminal justice institutions, and transitional justice. Before returning to academia, Camilo served as Deputy Minister of Justice of Colombia from 2022 to 2024, leading reforms on drug policy, prison humanization, and restorative justice. He was also lead researcher for Colombia's Truth Commission and collaboration with international organizations such as the UN Office of the High Commissioner for Human Rights and UNDP. Across his academic and policy roles, his work seeks to bridge critical socio-legal scholarship with practical efforts to advance more humane and democratic justice systems. Camilo will analyze new dynamics in the war on drugs. Phyllis Bennis co-directs the New Internationalism Project at the Institute for Policy Studies in Washington, D.C., and she is a fellow of the Transnational Institute in Amsterdam. She helped create the Iraq-era United for Peace and Justice Coalition, and co-founded the U.S. Campaign for Palestinian Rights. For 6 years, Phyllis served on the board of Jewish Voice for Peace, where she now serves as international advisor. She has addressed the UN General Assembly, worked as an informal advisor to several top UN officials on Palestine and other Middle East issues, and she was twice shortlisted as Special Rapporteur on Human Rights in the occupied Palestinian territory. She has written 12 books, the most recent of which is Understanding Palestine and Israel, which was published in 2025. And she has lectured at universities across the U.S. and around the world. Phyllis writes and speaks widely on Palestine and the broader Middle East, U.S. foreign policy, and UN issues, appearing regularly on Al Jazeera, Democracy Now!, BBC, C-SPAN, MSNBC, PBS, and other venues, and she writes in a wide range of U.S.-based and international mainstream and progressive media. Phyllis will discuss uniting for peace resolutions for movement activists, possibilities and limitations. We will begin today, our first faculty member, with Edre Olalia. Edre, the floor is yours.
Okay, good morning again. And good evening from here from Manila. Can you hear me? Is my audio okay?
Yes, we can hear you. Yes.
Okay, perfect. Okay. I'm speaking from Manila, and I'm supposed to cover the attempts to resist attacks on rights and international law using international legal remedies and to international work. I wonder if Neda can share my slide. Neda, can you share my slide so that our
Yes.
participants can follow? All right. Is it on now? Okay, I'm supposed to, while we're preparing for it, I'm supposed to talk about my view on how to use international law to stop the commission of atrocity crimes, ensure accountability for perpetrators, and redress for victims. And of course, more importantly, why is it necessary today, most importantly, and most especially given the circumstances and the world situation, to fight back against imperialist attacks on international law. And I'd like to zero in as a concrete example or template on how we can use international law and mechanisms in the case of the former president of the Philippines, Duterte, in the International Criminal Court, and highlighting why it is important to bring him to justice for his victims. So the scope of my presentation, subject to time limitations, will cover the following. As a preliminary background, the domestic context and remedies in the Philippines, which necessitates recourse to international legal remedies. And then I will go through the concept of universal jurisdiction. Is a slide now, Neda? After which I will zero in on the International Criminal Court, particularly the case of Duterte. And if there's time, I'd like to share some uh, views on United Nations human rights bodies and mechanisms. And for the people, the international remedy of and initiatives of people's tribunals and fact-finding missions, concluding with international solidarity work.
Neda,
I
we
don't see my...
lost the slides. Yeah, can you put
Yeah.
the slides up, please?
There you are. So you can see from the screen the scope of my presentation from the microcosm of the domestic remedies and context in the Philippines, the microcosm of the international remedies of universal jurisdiction, the ICC, the UN human rights bodies, people's tribunals, and international solidarity work. Next slide. The first topic as a prefatory, because the question is always, why do we have to avail of international remedies? In particular, in the Philippines, there's a context, no? Why we do have, are compelled to avail of international remedies and international solidarity work. And that will be answered by um, talking about the present legal milieu, the limitation of our domestic remedies, and the prevalent weaponization or instrumentalization of the law against critics, dissenters, and other so-called enemies of the state. Next slide. The legal milieu, just at broad strokes, there is impunity, prevailing impunity in the Philippines, arising from the lack, inadequate, absence, or even a skewed investigation and prosecution of human rights violations and violations of international humanitarian law. There is even the legal presumption or fiction in favor of state actors, including immunity from suit, the presumption of regularity in the performance of official duties, and the formal legalization of legal processes, which leads to human rights violations. Next, please. And from our experience, there's a lot of circumvention of legal procedure. I can give a lot of examples, but in broad strokes, this includes filing cases in distant places against individuals with no known address or fictitious address, only to find out that they are already facing warrants of arrest because they were not given due notice. And of course, the greater problem now in the Philippines, as in many other countries, of course, is the imposition of repressive laws and jurisprudence. The most use, and disabuse laws in the Philippines right now, as in many other countries, is on anti-terrorism or national security laws. And these are backed by jurisprudence and has victimized a lot of activists, a lot of rebels, a lot of critics, a lot of dissenters. In the Philippines, one other aspect that aggravates the legal context milieu, which gives us the imperative to seek further recourse to international platforms, is the endemic corruption in many branches and interstices of government, including the judiciary. And in the culture of the Philippines, the very personal character of government affairs and relationships, including influence and ties that bind, have also impacted on the rendering or non-rendering of justice to victims. Next slide, please. And worse, from the top level, there is condonation and inducement, just like Duterte, of acts and actors of violations, even promoting them to higher positions. And one other thing that prevails up until now is the multiple, not only double standard of justice. There's a double standard of justice between the poor and the powerless, so-called, and the rich and the powerful. But there's also another layer, which is the standard of justice between the rich but not in power and the rich but are in power. So those things are the factors that gives us a view of why domestic remedies are ineffective, inefficient, and unavailing. And finally, there is this reinvention rather and bending of the law. Traditional concepts, legal principles are redefined or reinvented to suit political purposes of the powers that be. So the limitations of domestic remedies in particular would include state immunity, presidential immunity, and even formal human rights laws are diluted, circumvented, and given the very protracted and delayed process of the Philippines, they do not give immediate, decisive, and effective remedies to the victims, including and as aggravated by the legal fiction that prevails in jurisprudence and in present laws. On the other hand, there are also limitations of international remedies, even if we do have to avail of these international remedies. From our point of view, this would include the lack of familiarity or expertise or experience in these international platforms, the political factors and intervention between and among states, the usually non-coercive, legally non-coercive powers or implementation of these bodies and platforms, and of course, the international relations and interests between states, including trade, military, and other ties between and among states. And finally, international legal remedies, especially for the poor, are very costly. So there are big obstacles that render us that compel us rather to seek redress in international alternative fora. Let me now go to the particular platforms of international legal remedies. This is not so much this is not very much familiar with many non-lawyers, no, but there is this concept of universal jurisdiction where perpetrators are brought to justice. This is the next slide now, Neda. Are brought to justice before domestic jurisdictions, either on the basis of the competence of national courts. Next slide, Neda. We're now in the universal jurisdiction, Roman numeral number 2. Next slide, please. There you go. This is the bringing justice to the victims against perpetrators before national or domestic courts, either on the basis of the competence of these courts for binationals. In other words, nationals who hold dual or multiple citizenships, or on the basis of the well-established principle of universal jurisdiction. In simple terms, universal jurisdiction is prosecution of individuals for heinous international crimes, for instance, genocide, aggression, war crimes, torture, and crimes against humanity in a national court of one state, even if such acts are committed in another state, especially and more particularly if the suspect or the accused has personal or property connections in that state where he is going to be tried. But this has limitations because it is cross-border. There are questions and debates on assertion of sovereignty and criminal jurisdiction and territoriality between and among states. The present and more popular so-called international venue is the International Criminal Court. That's the next slide now, Neda. For those who are not familiar, just to be on the same page, the International Criminal Court, or the ICC, is an intergovernmental organization, an international tribunal that sits in The Hague, the Netherlands. It has jurisdiction to prosecute individuals for the international crimes of genocide, crimes against humanity, war crimes, and crimes of aggression. The very same crimes that are happening in many parts of the world as we speak now. I'd like to zero in now on a concrete case of President Duterte, using it as an example or as a template for further or future communications against perpetrators of aggression and war crimes, including the President of the United States, the Israeli government, Netanyahu, and many others. The case of Mr. Duterte started actually in December of 2016. Next slide, Neda. Where the ICC prosecutor, I think it was still Benzuda, made a statement about the situation in the Philippines, saying that the Office of the Prosecutor is deeply concerned about the extrajudicial killings, and it said that it will monitor closely and record any instance of incitement or resort to violence. Remember, this was still during the time of Duterte, and the prosecutor said that it is considering opening a preliminary examination. Remember, this was 2016. That's 10 years ago. In February of 2018, the ICC prosecutor declared the opening of the preliminary investigation, which is the first step in the long, tedious process in the ICC. In 2018, the next step, which is the preliminary examination by the Office of the Prosecutor, started. Mr. Duterte, um, um, anticipating that is going to be held before the ICC, suddenly withdrew the Philippine state from the ICC. But this is very important as to the question of jurisdiction, which has been a subject of a long debate, but is now settled. But the withdrawal is only effective 1 year after. That means to say, all other incidents and crimes that happened before March 2019 are well within the jurisdiction of the ICC. 2 years after, the pretrial chamber authorized the investigation, and then 4 years after, that was last year, a warrant of arrest was issued by the ICC. And about a year ago, I think close to a year ago, Mr. Duterte was arrested and flown to The Hague and is now presently detained. What are the communications or crimes against Duterte? The communications for crimes against humanity, which was filed in August 2018 by the NUPL as lawyers for the victims of the organization Rise Up for Life and for Rights. It's the first case, it's the next slide now, Neda, that was directly filed by the families of victims themselves against a sitting. He was still the sitting head of state for the mass murder and other acts of serious injury to body or mental or physical health under the so-called bloody anti-drug policy and anti-criminality committed against thousands. The numbers vary, but one killing is one too many, whether it's 6,000, whether it's 25,000. Next slide. President Duterte is criminally responsible and liable, being the most senior leader and most responsible for these crimes because under the principle of command responsibility, he is the commander and superior authority over the police and the military and other state security forces who committed the killings and other atrocities. Next slide. Now the question, was prefaced by my discussion on the legal milieu of the domestic remedies in the Philippines. Why the ICC? First, the extrajudicial killings, arrests, and inhuman acts are so grievous and so heinous that they are of sufficient gravity to justify further action by the ICC. Second, Duterte was not investigated and is not being investigated in the Philippines, neither prosecuted for such killings during his period of presidency and even after his term expired. What are the charges? Thirdly, and this is the other slide, and there was a interchange on the slide. Thirdly, the Philippine justice system is unable and unwilling, is the second to the next slide, Neda, to prosecute Duterte because presidents, next slide, are expressly immune from suit under the Philippine justice system. For us, in NUPL and in IEDL, for that matter, this case underscores the enduring pressure from international and grassroots movements, but also tests the ICC's credibility to deliver justice and amid competing state interests. Next slide, please. Now, the question I was asked to discuss a little bit about the question of jurisdiction, because that has been a nagging question and debate and has always been raised by the lawyers of Duterte. Under Article 127 of the ICC rules, it states a state shall not be discharged by reason of its withdrawal, which it did in March 2018, from the obligations arising from the statute of the ICC while it was a party to the statute, because its withdrawal shall not affect its cooperation, and it has a duty to cooperate, and which for acts which were for incidents rather which were commenced prior to the date on which the withdrawal became effective, which is March 2019. Neither shall it prejudice in any way the continued consideration, and I quote, of any matter which was already under the consideration by the ICC prior to the date on which the withdrawal became effective. That is the crux of the question. So next slide. Does the interpretation of the term any matter which was already under consideration by the court, which was in March 2018, effective in March 2019, does it preclude the ICC from taking cognizance of an investigation begun after a country has withdrawn? The answer is a resounding no, because jurisprudence has taught us that any matter would include preliminary examination, which was prior to withdrawal. The phrase under consideration contemplates a situation of anything that is being considered in a generic sense, whether it's by preliminary investigation or examination, investigation, or what have you. And finally, the phrase by the court does not only limit its contemplation to the ICC per se, the pre-trial chamber or the appeals chamber or the trial chamber, but also includes the office of the prosecutor. So the question of jurisdiction or the lack of it has already been settled time and time again. The other nagging question, which has always been repeatedly raised by the defense of Duterte, the next slide, Neda, is his fitness to stand trial under Article 64, Paragraph 2 of the Rome Statute. However, the pre-trial chamber has adopted the reports of the medical experts who unanimously agreed that Duterte is fit to stand trial. However, nonetheless, the defense continues and attempts to relitigate the interim release in the first review of detention for conditions and citing medical reports as changed circumstances. So that's this question of fitness to trial is going to be revived time and time again. So where are we now? What is the status of the communication for crimes against humanity against Mr. Duterte and a handful of others? They have already been named, from generals to government officials who are in conspiracy with Mr. Duterte. As of date, the confirmation of charges which has been postponed, which is the next slide already, Neda, is a letter D under status. The confirmation of charges which has been postponed has already been finished last month. And the question of the interim release request by Mr. Duterte has been denied by the appeals chamber, but they are still reviving and resurrecting it time and time again. And finally, the question of jurisdiction has already been settled. But again, the defense is appealing it before the appeals chamber. So that is still a pending question. What is next now? The decision of the confirmation of charges against Mr. Duterte shall come within the next 2 months. So that will be March, April, after which the pre-trial chamber should have decided whether or not to confirm all or any of the charges brought by the prosecutor. And there are only 3 scenarios that we can expect. One, this next slide ready, Neda? And then what's next? The pre-trial chamber, no, it's there you are. Pre-trial chamber can either confirm, which means to say that it shall commit the suspect, Mr. Duterte, to trial before the trial chamber, or the pretrial chamber may decline to start the proceedings against Mr. Duterte, or it may adjourn the hearing and request the prosecutor to provide further evidence, for which reason the prosecutor shall have to conduct further investigations or to amend any charge. Next slide. So, what is the value of the ICC? Well, it has received a lot of criticisms. No, it is not a perfect institution. It has its own limitations. It may, so for some people, it has its biases, and there are a lot of procedural delays, jurisdictional challenges, and the susceptibility to geopolitical influences, just like what the United States government under Mr. Trump has been doing against the ICC and the prosecutors. The ICC has been rightly criticized, and this is the finding of the IADL in its Kathmandu Congress of last year. It has rightly criticized for its bias against investigating crimes committed by powerful states in the Northern Hemisphere, and it has an excessive focus, and that has been shown by the record, on the African continent. And Mr. Duterte is the only Asian leader so far that has been held to court. But to be fair, the ICC has taken some courageous steps, limited as they are, by opening an investigation, for instance, into the crimes committed since 2014 by Israel against the Palestinians, and more recently by issuing warrants of arrest against Israeli leaders, including Mr. Netanyahu. Maybe we can skip these human rights bodies. We can breeze through it. The next slide is robot number 4. I'll just breeze through it. This would include the UN Human Rights Council, the Universal Periodic Review, which is a mandatory review of the states every 5 years, I think, and the treaty bodies, for instance, uh, no, the committee, Human Rights Committee, the Committee Against Torture, and so on and so forth. These are bodies that monitor the implementation of the treaties on human rights mechanisms rather, and special procedures that would include thematic and country special rapporteurs and experts of different and varying topics under civil, political, economic, social, and cultural rights. I will skip the Uniting for Peace because I understand Ms. Phyllis is going to cover it. But I'd just like to point out that even as we engage these human rights bodies, they are valuable and they have their own significance and role to play, but they are constrained due to lack of enforcement powers, state non-cooperation because it is not mandatory to comply with these decisions, and of course, diplomatic interference. Now, we can probably skip the other parts from the UN Human Rights Council. You can skip that. UPR, treaty bodies. Treaty bodies, okay. There are 10 of them. Next slide. There you go. Special procedures, there you go. Skip it. And this is, I think, the more important thing, which is the people's tribunals and fact-finding missions. What are these tribunals and fact-finding missions, in particular the people's tribunals? In general, they are another form of the exercise of the right of people to seek truth, accountability, and justice. They serve as parallel political legal platforms initiated by the people themselves as credible alternative or even as complement or supplement to existing bourgeois or traditional legal or judicial and political measures and actions undertaken or existing or yet to be undertaken to hold perpetrators as well as hold perpetrators rather for violations of international law, including the basic right of peoples to develop. Tribunals, people's tribunals, are a fora, a very, very important fora, from the perspective or the lens of the people. They are not limited by tedious, protracted, skewed, belated, complicated, and even inadequate and politicized legal fora and traditional rules of procedure and evidence. They serve, next slide, as a secure and free platform for victims, next slide, Nada, and advocates and their organizations to present their narrative and experience anchored on evidence, of course, and legal arguments related to the alleged crimes committed. They document further and call out the horrendous violations of international law and further preserve, because there are already other ways to preserve evidence, and further preserve evidence to be utilized as reference or as reference at the proper time. Because there will be time, maybe not now, but there will be time for future legal action, including special UN tribunals or what we have discussed earlier, the remedy of universal jurisdiction or the exercise of universal jurisdiction. And finally, no, additionally, rather, people's tribunals and the proceedings memorialize the struggle of freedom-loving peoples of the world for the historical record, for the people's history, and should serve and does serve as moral inspiration for political action. Next slide. People's tribunals contribute to the tribulation and snowballing resistance campaigns and protests against violations worldwide. They are parallel to the pursuit of legal remedies, as well as advocating and engaging high-level intergovernmental bodies, and serve as moral, political, and diplomatic platform to exact accountability. They are part and parcel of amplifying the people's, amplifying, because it's always there, amplifying the people's collective right to self-determination, even the struggle for national liberation. Next slide. There are a lot of examples dating back to the Burton Russell Tribunal, to the IADL's Agent Orange against the Agent Orange War in Vietnam. In particular, the ICC proceedings was predated by two People's Tribunal in Brussels as well as in Washington in 2018-2024. There was also, for instance, the global uh, hearings on U.S. imperialism, sanctions, blockades, and economic coercive measures, including those in Venezuela, Iran, DPRK, Cuba, and many others. And most recently, there was this People's Tribunal on ecocide in Palestine committed by Israel, which was held in Brussels of last year. So what are these people's tribunals? And next slide, please. And fact-finding missions. They are basically grassroots, from the ground. Grassroots justice initiatives offering alternative spaces for truth-telling and mobilization, albeit with similarly limited legal force. And finally, this is very important. Given the limitations of traditional legal remedies, given the nature of people's tribunals, and given the gaps and the corruption and abuse and the undermining of legal principles and international law, the importance of international solidarity work, which is the next slide. This is our penultimate part of my presentation. That would include international alliances, not only among lawyers, but among peoples to people, conferences, worldwide statements, trial observations in many parts of the world, in Turkey, in many other countries where lawyers are being attacked, and of course, the value of submitting amicus curiae, or friends of the court submissions and legal opinions before national tribunals and many others, including, for instance, the initiative of the Friends of the Hague Group. In conclusion, what what are our takeaways? One, we must maximize the legal platforms and mechanisms in the international field despite their limitations character. We must, the next slide, Neda, generate broad international pressure and support and undertake organized campaigns in order to memorialize incidents and chronicle them for history and for future purposes, popular as well as legal. Next slide. We must, going back to my presentation, to my introduction rather, we must maximize international law and existing traditional redress mechanisms despite awareness of their nature, limitations, and gaps. We know that. But it may help. It may help. Not it didn't stop, but it will help. It will contribute in helping stop the commission of atrocity crimes. Maybe not now. Maybe in the next year, the next in time, to ensure accountability for perpetrators and justice for victims. It is imperative today to fight back against imperialist attacks, much more so now, attacks on rights and international law. As we see now in Palestine, in Venezuela, in Iran, in Cuba, and many other parts where the imperialist powers are dictating and using the law of the jungle and the law of the powerful rather than the law of the right. So it is important to hold accountable the likes of Duterte, the likes of Trump, the likes of Netanyahu, and many others for attacks on rights and international law. Next slide, please. I'd like to close by quoting the IADL declaration of last year with respect to the topic at hand. We must oppose the onslaught on international law and defend all achievements. We do have achievements. We have pushed the parameters of the limitations of international law. It has evolved to respond more to the people's rights and welfare. The achievement to defend these achievements of people's struggles against fascism and colonialism enshrined in international law. We must vigorously defend the progressive achievements. There are progressive achievements, including those in international humanitarian law, against all attempts to replace it with the law of the most powerful. We must enshrine further the achievements of the people's struggles in international law. These positive developments in international law that we have mentioned are only possible if they result from the struggles of the people. They're not going to come from the sky. They are part of the struggle. They're products of the struggle. They must be able to rely on the foundations of international law and develop as a result of the past people's struggle. This is the product of the people's struggle, the evolution of progressive trends in international law. That is why progressive and democratic forces around the world must mobilize. We must mobilize against these attacks on international law that we are witnessing at this moment. And may I quote, the system enforces, next slide, that the bred injustice.
Ray, we're going to have to close.
Yes, I'm already on my last slide. The system enforces the bred injustice are embedded by the law and are interpreted legal principles to suit political ends through legal weaponization are powerful. They are powerful. They are unscrupulous. They have all the resources at their disposal. They seem to be omnipotent and act with brazen impunity. But over time, together with the people, we will outdo, we will outwit, we will outlive them. Nay, the struggle for real freedom and justice will outlast them. Thank you. Muchas gracias. Merci beaucoup. Salamat.
Thank you so much, Edre, for joining us at midnight in Manila and for detailing the characteristics of impunity for the most heinous of crimes, for explaining the doctrine of universal jurisdiction and the historic case in the ICC against Duterte and the challenges that it faces. Also, for explaining the benefits and limitations of the ICC, the importance of people's tribunals, and international solidarity. So again, many, many thanks for a wonderful presentation. Next, we have Camilo Umaña. Camilo, the floor is yours.
Thank you, everyone, and thank you, Edward, for your presentation. I will try to keep it brief so we can perhaps have a round of discussions. I hope you are seeing the slides, the presentation. I think you are. In case you cannot see them, please let me know. The title of my presentation is New Dynamics in the War on Drugs, Markets, Technologies, and Imperial Power. I'm very glad to join you and very thankful for the opportunity to exchange. So, my main argument in this presentation is that the war on drugs is not new, but it's dynamic and changing. This changing landscape involves a degree of transformation, even though the war on drugs is a declaration that has been taking place since the 70s in the world, that started in the United States as a declaration, but has a longer history before. We can say now that this war has been fought in different places, most of them places where there is a production of plant-based drugs. But there has been some sort of a stability in this war on drugs that is transforming in the recent years. So part of my argument or the questions that I would like to raise with you is who benefits from this transformation, if there is such a transformation. The first thing I want to say is that I want to explain very quickly what the war on drug means. I think this phrase from George Orwell can be very interesting, saying that the war is not meant to be won, but is meant to be continuous, which means that the war on drugs actually has brought contradictory results to what it claimed to be. It claimed to be the defeat of consumption and production, so the reduction on the availability of illicit drugs, but also the opening of new opportunities for people and the adequate prosecution, judicialization, and accountability of criminal groups, and also the disruption of this illicit economy. What we see in the figures and all the statistics about this illegal economy is that actually the availability of drugs has multiplied, that new drugs come to the market every minute, and that there are more consumers than ever, and that this war that has been fought in different places, such as the Philippines, as I said, was explaining, but also Colombia, my home country, and elsewhere, especially in places and countries that are stigmatized as producers, has brought a lot of debt, a lot of costs, and human and environmental costs, but also cultural ones. So the pillars of the war on drugs are this strong distinction between consumers and producers, meaning that some countries, especially in the south, produce the drugs, and some countries, especially in the north of the world, consume drugs. It's also based on the assumption that it is an illegal economy that has no connection with the licit market and is fought through licit means against illicit actors. It's also assuming that there is one enemy, and although it is not clear if it is the drugs or the cartels or the criminal organizations or the illicit economy, it has an enemy that has managed to create this imagery of war that is being fought and that it can mobilize policies and also institutions and also programs from different organizations to fight against. So my argument is that this war, although seems to be permanent and continuous because the enemy is so abstract, is perceiving is we perceive now different transformations in this field. One of those is the amount of fragmentation of drug markets. So the idea of large cartels that manage every cycle of the economy of the illicit drug production has widely changed. Decentralized networks in small groupings and small scale producers find flexible trafficking cells that can adapt very well to different enforcement strategies, but also to different illegal economies, meaning that we are not finding as much as cartels that just do work on the illegal drug market, but also work on other illegal and legal economies, meaning that there is more fluidity and more learning from these groups that can regroup and can create new endeavors to support their illegal activities. This fragmentation also comes from a diversification of these illegal activities that are not only related to drug production and drug trafficking, but also related very much with other forms of exploitation, human trafficking, armed trafficking, the control of populations, illegal taxing, and sexual assaults and other harms into the environment, such as illegal mining, that all of them take place together in a form of platform and dossier, which is very open and multi-criminal. So this degree of fragmentation is not only territorial and in the way in which this business is organized, but also in which in the modus operandi, what they do. The synthetic drugs is changing the landscape because the global north is consuming more and more not only plant-based drugs as it used to, but also synthetic drugs. These synthetic drugs have created a new effect on these societies, especially because drugs as the fentanyl bring about a reality of a big strike on the structures of society, in which this fentanyl crisis not only creates addiction, but also a lot of deaths. So the United States, where it was, fentanyl was actually one of the legal confections of the pharmaceutics, had around 100,000 deaths every year for a lot of years. So this means that it's really lethal, and these kind of drugs are not only impacting the degree in which there is much more availability because of the easy commerce of these kind of drugs, but also because there is a lot of public health impact. Also because the technologies, especially the dark web, is helping a lot on the distribution. What used to be geographical obstacles and ways to try to traffic and produce different illicit drugs is now also taking place in virtual scenarios, in dark web, which means that it is the availability of technology also multiplies the degree in which these drugs are more available and they know how to produce them as well, but also the law enforcement capabilities are less effective. some of the consequences are that we are finding that, especially in the global south, the stigmatization about the production of drugs is being taking place, harshening enforcement and also increasing violence in local territories. So it is easier to claim that these production sites happen elsewhere, and that the multiplication of the risk factors around the addiction and also other public health issues comes from alien kind of factors and actors. So the enforcement of these actions is becoming harsher and harsher. And we can see that violence is less localized but remains concentrated, meaning that in Europe, for instance, you can see that port cities such as Rotterdam or Anvers have a big wave of criminal conducts, but also of violence derived from more and more traffic. You can see as well in different parts of the global north how local production is raising, not only of the production of cocaine, but also especially with the production of synthetic drugs, which means that there is a broader social problem. So the violence is not anymore contained into countries such as Colombia, but it's still is becoming more and more broad and more present in global north countries, but it still remains concentrated because we cannot compare what is happening, for instance, with the criminalization processes in countries as the Philippines or El Salvador, or the militarization of countries as Ecuador, or the strong military campaigns in different Andean countries with the realities of the global north. And also, the profit chains remain global, meaning that these global profit chains means that the earnings usually go to countries that have higher consumption, and the costs, the human costs, the environmental costs, and the other burdens, cultural ones as well, go to the side of countries that have been addressed as producers. Um, this, of course, correlates to the issue of imperialism in the sense that peripheral regions absorb instability while global demand remains stable. And when I refer to stable, I'm talking about raising every year. And of course, other regions absorb that this violence and stability. My second argument is that the geography of drugs is changing. The shift from plant-based drugs to synthetic substances that I just explained is changing not only the landscape of consumption but also production that is also taking place in global north. It is less dependent than on the territory as it used to be the plant-based drugs, and more potent and lethal, as what I was explaining through the example of fentanyl, but also the degree in which this has been delocalized, this production is becoming more and more evident. The technology, AI, and the dark web are helping to change the geography, the landscape of how this market is dynamizing and how it's thriving, especially in global north countries. The ways in which cryptocurrencies are also have a strongest role in stronger role in money laundering, and also distributing and know-how and knowledge how to produce these kind of drugs, and also have open new markets to not only the production but also the distribution and the consumption. Is a transformation that we need to address. My third argument, and I think this would be the last one before my conclusions, is that there is a new also or a degree of transformation in the military interventions. Although the war on drugs has always been fought using force and using the military and beyond also criminalization of people. This has been believed by different conservative policies to be the strongest and the most accurate tool, the most sensible tool to address these kind of issues. We are perceiving that there is more and more erasing of the borderline between public security and national security, in the sense that the use of the military and the understanding of the internal enemy, the adaptation of this strategy within the borders of the US is also changing the landscape, because the doctrine of the internal enemy that was broadcasted and also applied in Latin America by virtue of um, the strong intervention of the U.S. in the continent, is now also a narrative that has been taking place in the United States and has also effects on migration and the borders. And we saw how also this brought different effects into the international relations, especially with bordering countries such as Mexico and Canada. There seems to be also a narrow line now between the application of IHL and human rights. If there is any discussion on the framework on of the international law that can be applied to these kind of interventions, it is often challenged the validity of human rights in these kind of scenarios of control of these operations, and often it is used a language of international humanitarian law by which you can supposedly target people as enemies, and these adversaries could be also faced with lethal force, when actually international humanitarian law and human rights are not an option menu. It's they need to work together, and human rights are interdependent with international humanitarian law and are valid also in times of war. It's just that in times of armed conflict, there are other kinds of war of legal frameworks that come from international humanitarian law that are neither respected, because you need to have in place principles such as humanity, proportionality, necessity, and also prevention or precaution of any harm, especially to civilians, and distinction, of course, of civilians and combatants, and also armed forces. There is a paradox of constabularization, which means that the militarization of the war on drugs actually has increased the number of homicides and other lethal and other kinds of harsh violence in the territories where it has taken place. The militarization of police strategies, but also the rise of the use of lethal arms and other kinds of strategies of controls bring also a paradox where you offer or you sell security, but what you are receiving in the territories is less conditions of even survival. There is a wide amount of escalation. There are different studies that show how in countries where you have more militarized intervention in the field, there is actually an escalation from the criminal groups and a lot more of use of lethal means, and that there is a wide rupture and disruption of links within the communities and with the communities, between the rule of law and the state and government institutions with the communities, which makes also more difficult to create other forms of strategies that can complement and can bring also more social inclusion. Respecting your time, just some final remarks. First, the war on drugs is transforming, not disappearing, and this transformation we need to be aware that it happens within the international markets, not only domestically but also as an international matter that is confronting the very existence of international rules, but also is creating opportunities for the imposition of the use of force beyond the cooperation and multilateral agreement between states. So it's also harming the validity of international law. Is harming not only the rights and the existence of human rights, but also the very existence of frameworks that can help us to move forward in a new and more humane way. These new dynamics that I refer to are not only about fragmentation, the entry of synthetic drugs, and the use of technology, but also new forms of advancing the use of force that have emphasized on military strategies targeting vulnerable populations as the Caribbean operations, and that actually involve an attack not only to those communities but international public law and international human rights. We should think of a framework where we consider drugs as a social issue and not a war, that can actually address structural inequalities that start with not only poverty and exclusion, but also how to address consumption and how to address also other issues at the societal level. And we need to start thinking that these illicit markets are actually embedded in the illicit economy. There's a hybridization and a lot of dialogues that need to be conducted to be more honest about how illicit economies and legal economies nourish from these illicit economies. These are my final remarks. And again, thank you so much. I hope later on we can have some debate and discussion. Thank you, Marjorie, and to all the team.
Thank you, Camilo, for explaining the parameters of the war on drugs, its economic and political aspects, and how it's used to justify military intervention and repression, including recently, in Venezuela. And also the way that international humanitarian law and international human rights law are miscited to rationalize lawbreaking. So thank you again very, very much. Our last faculty member, but certainly not least, is Phyllis Bennis. So Phyllis, go ahead.
Thanks, Margie, and thanks all of you for being here. I'm sorry I can't be with you this morning. The scheduling didn't work out, but hopefully this will be of some use. I was asked to speak about specifically the Uniting for Peace precedent at the United Nations and how that can be used, what are its values, what are its limitations. But before I jump into that, I want to say a few things about the history of the UN that I think are very relevant here when we're talking about the limitations of international law. One is that from the time it was created, the UN has always had this contradiction between the forces that are the most democratic, such as the General Assembly, one country, one vote, and the agencies that are the most powerful, like the Security Council, where the permanent 5 members, of course, have and use their veto that comes from power. So there's a huge challenge in that context that so much of international law lacks institutional enforceability. It's the crisis of enforcement. And that means the veto, that means the General Assembly is weaker, its decisions are not considered binding in international law. All of those things are challenges. Now, in the last couple of years, particularly in the context of the genocide going on in Gaza, there's been some real challenges to those limitations. So the biggest one, of course, was the decision by South Africa to bring its case against Israel in the ICJ on the question of violations of the International Covenant Against Genocide. The model here goes to what I was talking about earlier, that in the past, where these kinds of cases happened, you had a situation where the various countries would bring to the Security Council a proposed resolution, including what kind of sanctions could be brought to bear on the apartheid regime in South Africa. And they would be immediately vetoed by the US. So they would bring them to the General Assembly, where they would probably, in most cases, be passed with an enormous margin, an enormous majority. Sometimes it would be brought to the International Court of Justice. Again, there would be a positive ruling from the court. But the court and the General Assembly would say, we can't do anything to enforce it, so it's just going to pass. But what happened, if we look back at the 1980s, when the anti-apartheid movement around apartheid South Africa was at its height, you saw that these resolutions that were passed in the General Assembly, for instance, served as a kind of menu of options, the kinds of sanctions that could be imposed: trade sanctions, banking sanctions, arms embargoes, all these important things. And countries were urged individually to carry them out. It wasn't binding, they didn't have to do it, but because there was an international movement against apartheid South Africa, pressure was brought to bear on all these governments all over the world, and one after another, after another, after another, collapsed in the face of that kind of pressure and imposed sanctions. Eventually, when enough countries had done that, including key allies of the United States, the US finally gave in. This was during the Ronald Reagan years, which was one of the most reactionary periods of the modern era in this country. But nonetheless, Reagan was sort of forced by public opposition to give in and allow sanctions to be imposed against apartheid South Africa. That decision, where because the US was so powerful, but not only militarily, but economically in supporting the apartheid regime in South Africa, that led to the conditions under which South Africans were able finally to carry out their own liberation and overthrow the apartheid regime. So I think we can look now to that kind of a model, which I'll come back to later. But I think the challenge that was raised at the ICJ by the South African decision is a very critical one. And it goes to not only, of course, the question of Israeli accountability, which had always been prevented by the United States. The US was never going to allow its top ally in the Middle East to be held accountable in the International Criminal Court, in the International Court of Justice, by the Security Council, not in any way. So in that context, you have the South Africans saying, you know what, this is our chance and we are going to use it. The other challenge that South Africa raised was with the very nature of the ICJ, which traditionally was seen as an instrument of the white colonial countries, right? Who gets to use the International Court of Justice? It's not poor countries. You know, you didn't see cases coming from Bangladesh and from Chad. You saw countries, generally, it was the countries of Europe, of North America, of Australia, New Zealand, and a few other wealthy countries, perhaps Japan, perhaps South Korea, once in a while Russia. But basically, the global South was excluded. Suddenly, here you have an African country that had itself overthrown apartheid coming to the court and saying, you belong to us too. It was an extraordinary break with that narrow definition of the past. So all of that has been, I think, very important in terms of how we see the models of how enforcement can happen at the United Nations in the context of international law. So where are we now? We're looking at the second term of Donald Trump as the president of the US and the would-be king of the world, in which he is consolidating his attack that has been going on for a long time against international law and international institutions as a whole, particularly, of course, the United Nations itself. So what we saw in the recent time has been the willingness of the Trump administration to absolutely ignore the UN Charter that says in Article 2 that no nation should go to war against any other nation, with two very narrow exceptions. The charter was ignored. The restrictions of Article 51, which are basically either the Security Council gives permission, authorizes a military attack, which certainly did not happen here, or immediate self-defense if an armed attack occurs until the Security Council can meet. So it's two kinds of restrictions, even on self-defense. So you can't just say, it was self-defense, we had the right to go to war. It's only if an armed attack occurs, which it did not in the case of Iran. And if we look back at the other cases of this first year of Trump's second term, right after his inauguration, he began a huge bombing campaign against Somalia. In March, he attacked Yemen, carrying out massive attacks that killed civilians. In June, of course, was the first US-Israeli assault on Iran. On Christmas Day, he attacked and bombed Nigeria. In January, it was the attack on Venezuela. And now, again, another second, much worse attack on Iran. So in all of those instances, the charter was ignored and violated. Article 51 was ignored and violated because there was no permission granted from the Security Council and there was no claim of self-defense. Iran had not attacked the United States. Then you have also ignoring the charter and violating international law in the context of Gaza and to some degree the West Bank, but particularly in Gaza, where the US not only protected Israel from being held accountable for its violations of the Convention against Genocide, but it enabled the Israeli genocide by funding it, arming it, and protecting it, so that there was never any accountability for Israel's vast violations. The US was more than just a supporter, it was also culpable for those violations itself. What we have right now internationally is what I would call a regime of international fear. For governments, that means fear of the Trump administration imposing new tariffs, imposing sanctions, maybe using military force. And the result is there's a huge fear of even disagreeing with Trump's claims, the fear that he will be insulted, that he will not allow disagreement. So appeasement becomes the name of the day. And countries around the world are now trying their best to appease Donald Trump, which, aside from the moral degradation that says about governments, it also doesn't work, something we have found to our peril in this country. So the pressure on NATO to escalate their military spending to 5% of GDP, unprecedented. But virtually all of NATO these days is going ahead and trying to move to 5%, forcing the purchases of US military equipment, all of that. If we compare this undermining of international law with that of the George W. Bush administration, who first went to war after 9/11 against Afghanistan and then against Iraq, there's a vast difference. This is far worse. Bush violated the UN Charter also by going to war against Iraq and against Afghanistan. It's a trickier case around Afghanistan, but it was not legitimate self-defense. I won't get into that now. We can in the questions later if you want. But in the question of Iraq, there was no issue, there was no question, there was no challenge to the understanding that going to war against Iraq was in violation of international law and a violation of the UN Charter. How do we know that? We know that not least because the Bush administration spent months, almost a year, trying desperately to figure out how to get the Security Council to vote to authorize its war. The Security Council stood defiant. It was one of the great moments of the United Nations. For 8 months, the Security Council refused to support a US war against Iraq based on lies, based on false claims of weapons of mass destruction. Sound familiar? It should. But the difference was That effort, although it ultimately failed, it was an acknowledgement that there is something called international law. There is a UN charter. There is a requirement that if a war is to be legal, it has to be authorized by the Security Council. Bush ultimately couldn't do it. He couldn't get enough countries. There were 6 countries of the global south that were non-permanent members of the council at that time, and they stood together. These were all countries who could not have stood up to the US on their own, but together they did. Those countries were, if I can remember them, it was, let's see, it was Pakistan, Chile, Mexico, and 3 African countries, Cameroon, Guinea. I used to know this in my head and it's escaping me, but it was 6 countries which were disdainfully named the six-pack in the US press. The six-pack stood defiant, refused to give Bush the credential that he wanted to go to war. The result was, when he went to war with Tony Blair, with the Brits, that war was explicitly illegal. It would have been immoral, it would have been horrifically wrong, but now it was all that and explicitly illegal because there was no authorization from the United Nations Security Council. So if we look at the examples now under Trump, just pick 3 examples. When the Security Council not only accepted, but embraced and endorsed Trump's so-called 20-point peace deal for Gaza. You all remember this back in November of last year, November of 2025. November of 2024, sorry. The Security Council not only didn't condemn it as something that was going to authorize permanent occupation, permanent apartheid, no end to genocide, no call for Israeli withdrawal, etc. They embraced it. They endorsed the entire 20 points. It was one of the lowest levels of the United Nations, one of the saddest moments, one of the most explicit indicators of the collapse of the UN as a viable institution to protect international law. It was tragic. It was tragic. In June of last year, when first Israel and then joined by the United States went to war in the so-called 12-day war against Iran, again, there was no response from the Security Council, despite the fact that this represented 2 nuclear-armed states, the United States and Israel, going to war against a non-nuclear state, something that is directly prohibited through all the efforts at stopping the spread of nuclear arms in the world. And then third, what are we looking at right now? Full-scale war, not only in Iran now, but across the Middle East. And the Security Council resolution that was passed last week condemns only the victims of that war of aggression. Because remember, this is the crime identified in the Nuremberg trials as the supreme international crime, the crime of aggression, going to war against international law, going to war illegally, means all the other violations, war crimes, crimes against humanity, stem from that first crime. The US and Israel were carrying out a crime of aggression. This time, the US launched a war of aggression against Iran, and the Security Council voted a resolution 13-0, with Russia and China abstaining, not using their veto, that had no mention of the war of aggression, that had only the condemnation of Iran, which had violated international law, no doubt, in its self-defense. It had the right of self-defense. It did not have the right in implementing self-defense to attack civilian targets, some of which it did. Should have been held accountable for that. But the notion that they would hold accountable only the victim of this war of aggression was another absolute travesty. So now we come to the Uniting for Peace precedent in the UN. I think you probably all know the basic history, that this was something that was created by the United States in 1950 as a way of figuring out how to get, again, the search for legitimacy, the search for authorization of a US war in Korea. They wanted the Security Council to endorse a war. Security Council wasn't game to do that. Eventually, there were a lot of diplomatic maneuverings. At one point, when the Soviet Union had left because they were protesting the lack of willingness of the Security Council to allow China to take the earlier seat of Taiwan from before the war. So all of that is going on. I'm not going to go through the whole history here. But the question is, what happened? They created something that was soon called the Uniting for Peace resolution. And what it said was that in a moment when the Security Council is paralyzed because of the use of the veto, that it can't move on an issue that belongs only to the Council, which, as you know, in the UN Charter, the issue of peace and security belongs to the Security Council, not to the General Assembly, except under very narrow circumstances that are considered exceptions. Ordinarily, only the Council can take up the question of threats to international peace and security and figure out what to do about those threats, right? So in this case, what happens? They pass a resolution that allows the General Assembly to take up the issue of peace and security, which would otherwise not belong to the General Assembly at all, if the Security Council was paralyzed by the use of a veto. And what it could do is decide what should happen and recommend to member states that they carry out those decisions. That was huge, because until that time, the General Assembly was pretty much prohibited from dealing with any issue of peace and security that might be going on around the world if the Security Council was dealing with it. You've seen probably on some UN resolutions, Security Council resolutions, at the end of it, it says a famous line, "The Security Council remains seized of this issue." What that means in Diplo speak, someday they'll learn to speak normal languages instead of Diplo speak, but not yet. What it means is, it's our issue, keep your hands off. So it's a reminder to the General Assembly, this belongs to us, not to you, so butt out, right? To be not diplomatic about it. But there are limitations to the campaign around Uniting for Peace, and they are very important, and they're not as well known. So you see sometimes campaigns. There was a campaign recently, I think it's maybe still going on, demanding that the General Assembly pass a resolution under Uniting for Peace to deal with the genocide in Gaza. The problem was the United Nations had done that already. They had started a resolution in 1997, I think it was, 1997, on issue of settlements in the West Bank and in occupied East Jerusalem. The Security Council, of course, the US vetoed, the Security Council was paralyzed, so they went to the General Assembly, and this was now the 10th special session. Special emergency session is what they're called, when the Council is paralyzed and the General Assembly takes up an issue under Uniting for Peace. They do so under emergency circumstances. So in that context, the General Assembly was now taking up the question of Israeli occupation. And since that time, the 10th emergency session has been called back into session, I think about 25 times over the years. It never ended officially. So at any time, any member of the General Assembly can call for a meeting of the General Assembly to return to the 10th emergency session to take this up. So in this case, in September of 2024, the General Assembly had done just that. The context was, this was just after the International Court of Justice in The Hague had issued in July of that year, July of 2024, an extraordinary advisory opinion that was responding to a request by the General Assembly from 2 years earlier. The Assembly had asked the ICJ for an advisory opinion on the legality of Israel's prolonged occupation. of the OPT, of the occupied Palestinian territory, the West Bank, Gaza, and East Jerusalem. Because there had been many resolutions passed over the years, both a few in the Council and many in the General Assembly, finding a variety of Israeli practices to be illegal. House demolitions was illegal. Land confiscations was illegal. Putting whole villages or towns under curfew was illegal, collective punishment. All these things were illegal. But they were finding that those acts were illegal. It was based on the notion, which was the origins of the Geneva Conventions, of course, that in a wartime situation, occupation can be legal. But when there is an occupation, the occupying power is obligated to do and not do certain things. So they are obligated, for example, not to use collective punishment, that no one can be punished for anything that they didn't personally do, that they didn't commit a crime personally. They can't be punished for it. A whole set of things. You all are familiar, I think, with the Geneva Conventions. But it did not say that occupation itself is illegal. In this case, the findings of the court were absolutely extraordinary, surprised everybody, even those who were pretty sure that the court was going to come out and say that because of the length of this time, that this occupation at least is illegal. And it did say all of that. But it also called for responsibilities as a result of these crimes. So it laid out a whole series of things that Israel had to do, laid out a whole series of things that other countries had to do. Members of the United Nations, members of the International Court of Justice, had obligations under international law, according to this opinion, that were designed to end Israel's occupation. The problem is the ICJ, like the General Assembly, doesn't have any enforcement power of its own. It doesn't have an army. It doesn't have a police force. It doesn't even have a process server to go around and serve some dictator or some democratically elected president who's committing war crimes with papers. It has nothing to enforce. So it turned it over to the United Nations and said that they wished that particularly the Security Council and the General Assembly would take it up. Well, the Security Council took it up. You can imagine how fast that was resolved. Quick veto, and that was done. And then it goes to the General Assembly. So a month later, in September, that opinion had come out in July of 2024. In September, the General Assembly votes on an extraordinary resolution, which, among other things, called for everything that the ICJ had mandated in its advisory opinion and added to it everything that the ICJ had ordered in an opinion that was not advisory, but was officially binding in international law, even though they could not physically enforce it, which included all of the preliminary motions that were imposed on Israel before they even have made a final ruling. And those were now incorporated into this resolution. So the resolution called on Israel to impose a whole host of sanctions, of the arms restriction, ending the entire presence of Israel in the occupied territories. And they said that means withdrawing all military forces, ending the settlement process, evacuating all settlers within 1 year. That was last November. That year was up. You didn't see a lot of settlers being evacuated. But that was the order of the court, that all the illegal settlers, which is about 750,000 people across the West Bank and occupied East Jerusalem, that they all were to be evacuated. The return of the land and goods that were taken since 1967, the dismantling of the apartheid wall, the right of Palestinians to return to their homes, although it didn't specify whether they were talking only about the 67 territories or those Palestinians who were expelled from their land in 1948. But still, any return had never been mandated like this. And then this resolution called on member states to do a whole bunch of things, also taken directly from the ICJ's opinion. It called for all states to meet their obligations under international law and international humanitarian law, to pressure Israel to obey international law, including particularly detention and the grave breaches that it had identified, to end discrimination, including apartheid. It did so through a rather twisted bit of logic, as they do, without ever saying the word apartheid, but just said that the work of ending discrimination must include all the components of Article 3 of the CERD, the Convention Against Racial Discrimination, which includes specifically apartheid. It called for all states to abide by everything in the ICJ opinion, that there should be no recognition or assistance to occupation, to the occupation itself, no importing of settlement-produced goods, and crucially, it called on all states to stop provision or transfer of arms, munitions, and related equipment if there is reasonable grounds to suspect that it may be used in the occupied territories. Now, knowing what we know about the Israeli military and its role in the occupied territories, any military equipment they would receive would reasonably be suspected that it may be used in the OPT. So they were calling for an arms embargo, as well as other sanctions, travel bans, asset freezes, an end against settlers who were charged with violence, support for Israeli accountability. It was an extraordinary thing. So what does this mean, that this was passed under Uniting for Peace? Unfortunately, what it does not mean is that it is somehow enforceable by itself, because Uniting for Peace allows the GA to take up issues that would ordinarily not belong to it, particularly the issues of peace and security, but it does not allow the General Assembly to enforce its own resolutions. So when it was used against Korea, for instance, it was because the United States mobilized under that resolution an armed force to go to war in Korea. In theory, this resolution that I've been talking about around the Israeli occupation and Israeli genocide, this resolution did not call for a protection force, unfortunately. It would have been good if it did. But even if it did, it would not have made that enforceable. It would only have happened if a member state was prepared to put together an armed force to protect Palestinian civilians. And what we know so far is that no state, including those that have done a lot in this direction, South Africa, Colombia, Ireland, Malaysia, some others, no state, including those, have been willing to impose all of what was called for by the resolution. And certainly there is no state that is prepared to send its troops for a protection force. We do have Indonesia saying we'll send 20,000 troops for the US stabilization force. That's a whole different kettle of fish. That's a whole different issue. This would not have made that happen by itself. So what I want to just say in ending, because I want to have time here for questions, is what do we mean that the Uniting for Peace is so important? It's important as a framework for global engagement, for civil society engagement, for social movements engagement with the United Nations, especially because it presents a menu of sanctions that are needed, including, crucially, for those of us in the United States, also those in Germany and Italy, an arms embargo. Those are the three countries providing Israel with its arms. Overwhelmingly, the United States, a smaller amount from Germany and a tiny bit from Italy. It cannot be vetoed, but because there's no institutional enforcement, it needs the kind of movement pressure, civil society pressure, social movement pressure that I was talking about earlier that we saw in the 1980s around apartheid South Africa. It also should be recognized that when the first steps are taken by a few countries, there's a kind of pressure that starts to build, that other countries start to press for that kind of implementation. So what we need now is not a new resolution. We need enforcement of the existing resolutions And that means we need a global movement against Israeli genocide, against Israeli apartheid, against US and Israeli wars of aggression, of all of these things. This is how we are going to have enforcement of international law. It's never going to come in the current situation from the institutions. It's going to come from us. Thank you.
Thank you so much, Phyllis, for detailing the contradiction inherent in the U.S. system, placing it in a historical context, and talking about how Donald Trump has taken defiance of the charter to a new level. I want to ask you basically two questions, and then they're part of the same topic. And one is, why hasn't Uniting for Peace been convened yet? In other words, why hasn't the General Assembly convened under Uniting for Peace vis-a-vis the current U.S.-Israeli war of aggression on Iran? What countries could be convinced to defy the U.S. and convene under Uniting for Peace? I guess one country needs to initiate it. And Donald Trump is pressuring NATO countries to use military force to open the Strait of Hormuz, and they're waffling around. He's basically blackmails them the way he blackmails, not with tariffs. The Supreme Court has said, at least under the section that he had used, the statute, they weren't legal, but he certainly can wreak a lot of havoc. So just to throw those things out, whatever you'd like to answer.
Yeah, those are really important questions. On the first part, why hasn't there been? I think we go back to last week's decision at the Security Council. The vote, as I mentioned, was 13-0. Every country, not other than Russia and China, voted for this condemnation of Iran that never mentioned the war of aggression being carried out by the United States and Israel. 138 other countries signed on as co-sponsors, which I found shocking. Countries from every continent, African countries, Latin American countries, Asian countries, as well as Europeans and others. It was shocking that so many countries were so eager to jump on the bandwagon of blaming the victim for this war of aggression, which is what that resolution does in the context. As I said, Iran has violated international law, the war crimes, in some of its attacks on civilian targets in legitimate places where the U.S. military bases are that are being used to attack Iran. That would be self-defense. But there have been attacks on civilians, so that is appropriate. But the notion that it only goes after the victim of this war of aggression is a travesty. And the fact that so many countries were so eager to sign on to it means it does not bode well if any country or group of countries went to the General Assembly to call for a Uniting for Peace resolution. It means it would probably not come close to passing. I think right now what's needed is to look at the existing resolution that was taken in September of 2024 that calls for critically important things. It does not call for a protection force, as I said, but if there could be a vote, a campaign to enforce what that resolution does call for, starting with the arms embargo, that is what would stop the Israeli ability to carry out its continuing genocide and its continuing assaults on Lebanon, on Syria, on Iran, on Yemen. So all of that goes back to the U.S. arms that are being provided. Without those arms, that genocide does not go forward. Imposing that resolution, making it real, implementing it, that's what's so critically needed. Another resolution that's not going to be implemented is less useful. It can be useful, but it's less useful than enforcing the one that already exists.
So how do we participate in and build that kind of a campaign?
I think it means two things. One, it means being in touch with people all around the world who are doing some of this work already, but not enough of them are. I think, this Uniting for Peace is a bit of a wonky, if I can use that term, of a wonky issue. It's not something that ordinary people are familiar with. Why would they be, right? It's a tricky issue. And as we know, even people that are very familiar with the issue don't always understand what it does and doesn't do. I think a lot of people believe that it's enforceable automatically, that if it passes, somehow it just happens. It doesn't work that way. That's the problem. So we need to be sure that our counterparts, our friends, our comrades in countries all around the world, whose governments may not be sending arms to Israel, because very few are, but they are probably buying Israeli military equipment. They're probably buying Israeli surveillance equipment to use against their own people. Most governments do that because the Israelis make the best. They are probably buying various goods from Israel that include settlement-produced goods, because the Israelis refuse to mark whether they are settlement-produced or produced in Israel. So you have a phenomenon like the Europeans in the association accord between Europe and Israel, the European Union and Israel. The association accord says that the tariff-free trade agreement between them does not include goods produced in settlements. But the Israeli position is, we don't distinguish. And so the Europeans have just accepted it. It's like, oh, okay, well, sorry, I guess we can't distinguish, so we'll take it all. Instead of saying, okay, then we're not going to buy anything from Israel. If you can't tell us what's made in settlements and what isn't, we're not going to take the chance. We're not going to buy anything from you. They could do that. They're not doing that. So there's all these options. We can play some role, particularly the people in this class who are lawyers, legal workers, human rights activists, people who are dealing with the law in places all around the world, informing people about how they can use this, going to their government with this list of, it is like a menu of the sanctions, and say, we want to do all of these. Some of them don't apply to us because we don't do these bad things, but every one of these bad things we can stop doing. And we don't want to be part of the cohort of outlier countries. We want to be part of the cohort of countries that take seriously international law. That's how we build a movement. That's number one. The second part is that we have to understand that for those of us in the United States, and hopefully that's not everybody on this call, but for those of us in the United States, we do need to focus on our own government. I know that an awful lot of people, because I get the calls, will you come and speak to our group about how we can work on the UN? How do we pressure the UN? We don't have a whole lot to say to the UN, frankly. On occasion, there can be a particular way, you know, when Rabbis for Ceasefire sat in at the Security Council, that was kind of amazing pressure on the United Nations in the early stages of the Israeli genocide. Most of the time, we don't have a whole lot of influence on the United Nations. And I know for a lot of people in the US, there's incredible frustration, absolutely legitimate frustration at our inability to make our government respond to what is an overwhelmingly popular public opinion. But that's what we have to do, and we have to change it. And it's going to take a long time, and it's frustrating, and it's more interesting to work at the UN because there's openings there. There's countries that actually do take international law seriously. And I have been privileged on a number of occasions to work with some of those countries on some of these issues. But at the end of the day, our obligation is here. And it's often a lot more interesting to work at the UN, but it's a lot more important for us in the US, and this does not apply to the rest of the world, to keep the focus on what we're doing at home. I hate to say it, but I think it's true.
Well, I can't disagree with you, Phyllis. And on that note, I want to thank you so much. I understand that you were physically unable to attend in person, but we love having you. We'll have you back. Of course, you're a member of the Scientific Committee of the People's Academy of International Law, and just an invaluable resource. So thank you once again. Much appreciated. Take care.
Thank you.
Bye-bye.
Bye.
Okay, so we're almost out of time, but there is a question for Camilo in the Q&A box. Camilo, what is the role of U.S. finance capital in the increasing militarization of production and distribution of drugs?
Thank you for the question. Well, it is hard to say, and because and at the same time it's easy to say. It is hard to say because it's multinational capital, so it's not only about one country. It's I like to call it the global north because it's the participation of great networks of capitals that actually move within the framework of different countries, and how they not only participate on the money laundering industry, but also on the side of producing and enhancing the war. However, the arm production in the United States is one of the biggest business, and of course the militarization is not only about assistance, but it's also about providing a lot of the materials and war materials that this war is made of. So it is not only ideological, but it's also a war that has been fought using capital's influence, and it's also well present in the military industry in the United States, of course. And this is not only about arms; it's also about precursors. It's also about chemics. It's also about Roundup and about other kinds of also of substances that are being used and have been used for this fight. And so I would leave it like that. Yeah.
Okay, thank you so much. One last question. Can one petition the ICC to investigate the U.S. president for crimes against humanity based on universal jurisdiction? Actually, the ICC operates on the basis of the Rome Statute. That's different from universal jurisdiction. Universal jurisdiction is a theory that allows individual countries to prosecute foreign nationals for the most heinous of crimes. And I want to thank our esteemed faculty, Edre, Camilo, Phyllis, our administrator, Netta, our interpreters, as well as the People's Academy Task Force. Our next program of the People's Academy of International Law will be Nuclear Disarmament and the Right to Peace, very timely, and it will be scheduled for Earth Day, Wednesday, April 22nd. You will receive more information soon. Thank you all for coming. See you next time.